by the use of grave forms of force, but also less grave force, including the existence of military maneuvers near the border of neighboring countries. Here, Your Excellencies, as the wall is highly advanced and equipped with lethal weapon systems, it can be considered as similar, if not equivalent, to a military maneuver. Moreover, it is clear that the applicant is not in favor of the establishment of the wall and has yet to regulate its usage further. Thus, the activity of the wall, which also includes Ottawa territory, is unlawful. In pursuant to the nuclear case, also concluded by this court, such stated readiness to use an unlawful weapon indeed threatens force to secure the territory of the country.
Yes, but but nearly soldiers guarding the border, I think that the same would have to show the use of force.
Thank you, Madam. Regarding such situation, we believe that we also acknowledge the presence of militia that has been established upon the border. However, we see that the soldiers itself should also be considered upon whether they are armed with lethal weapons that could kill civilians or many kind of targets that have been existing upon the border of the Ottawa. I'd like to continue to my sub-arguments. The second one is the justification of the threat and use of force itself is when the attack is done on the grounds of self-defense. This has been provided by the Article 51 of the UN Charter. In Nicaragua case, self-defense can be justified by two principles, namely proportionality and necessity. I will now address the test of proportionality. Proportionality is measured upon the military values of the target, whether the incidental harm caused by the military advancement is considered excessive. Here, the presence of militia, which has low military value, is not proportionate with the high military value of the wall itself, because the wall is a permanent infrastructure which may expose civilian population of short-range soldiers. Thus, the wall does not pass its test. Now, I will now address the test of necessity. As referred to the Nicaragua case, a threat or use of force can be justified as self-defense if it has been proven first that the state has been the victim of an armed attack. Here, there has been no armed attack on behalf of the state of armed groups, irregulars nor mercenaries, along the border of Ottawa, which now raises a question upon the motive or deployment of the wall itself. As the wall cannot meet the principle of proportionality and necessity, its establishment and use is deemed to be illegal. I will now proceed to my second argument. Your Excellencies, international human rights law guarantees the right to life and privacy of individuals. In pursuant to this, we submit that Rasasa has violated International Covenant on Civil and Political Rights because of three reasons. First, ICCPR may be applicable extraterritorial. Second, the wall will arbitrarily deprive life. Third, the wall conducts surveillance not in accordance with steps provided in Article 17 of the ICCPR. Moving on to my sub-arguments. First, in pursuant to the case of construction of the wall, this court stated that ICCPR may be exercised outside the national territory due to its aim and purposes in which it should protect human rights of all individuals and done by all member states. That is why we see the protection of right to life and protection of arbitrary attacks or interference of Ottawa people should be in regards to this ICCPR implementation of Ottawa. Second, the conduct of arbitrary deprivation of life is strictly prohibited. As stated before, the wall carries potentially lethal weapons, in particular 0.5 caliber machine gun, which can only be used when a serious and imminent threat has been present. However, the current threat cannot be classified as imminent, as the militia encountered by both parties is not equipped with similarly advanced technology. Third, as ICCPR prohibits arbitrary or unlawful interference in attacks, the surveillance authorized by states can only be conducted on the basis of law, in which means the Ottawa should also have regulated the way the wall has been exercised.
Yes, I think there has been militias around the border somewhat attacking civilians. It's awesome because that's not amount to a problem that renders
I understand your concern, Your Excellencies. However, we see that the military or the technological advancement of the wall itself, in which it's not conducted by humans, nor it is measurable of the attack or the responses of the wall itself, cannot guarantee that this is not proportionate, that this is proportionate with the militia present in the border. I will now proceed to
Yes,
ma'am.
around to imminent threat in the country.
Thank you, Madam President, for the question. The imminent threat itself is when as I would like to refer to the armed attack and that has been stated before, that it should be done by on behalf of state of armed groups and irregulars and also mercenaries. This is not the case regarding the militia itself. The militia is insisted upon civilians itself. Thus, we see that this is not an imminent threat that requires such wall to be existing in the first place. I continue to my third argument. Your Excellencies, to keep the war of humans human, the conduct shall be in accordance with international humanitarian law. The deployment of the wall, however, has violated the law because of three reasons. First, the establishment of the wall is against the principle of humanity and dictates of public conscience. And second, the establishment of the wall does not meet the principle of proportionality, distinction, and precautions. And third, the establishment of the wall is not in accordance with the principle of predictability and reliability. Moving on to my sub-arguments. First, since law has yet to be regulated, according to the Article 1, Paragraph 2 of the Protocol 1, should be first determined if it meets the principle of humanity and dictates of public conscience. We understand that the wall is a fully automated weapon. It has no or zero human intervention, even if it's in deployment, nor it's in its operation and evaluation. Thus, we cannot guarantee if this international humanitarian law is pursuant towards the operation of the wall itself. Because as in accordance to Article 1, Paragraph 2, in which consisting of Article clause, if one weapon has yet to be regulated upon IHL, it should be regarded upon these two principles. This wall has raised fear and deep discomfort that the wall may have caused or have the potential to cause unacceptable harm as it is equipped with lethal weapons. This emphasizes the argument that the wall is against the dictates of public conscience. Second, the rule of distinction needs that the setting where the legal autonomous weapon system is located, the data input, and their relation to the rule of proportionality. We see that there is no certainty nor guarantee that this can be not consequentially to indiscriminate attack, since we cannot assert how the wall can be how the wall conducts its analysis upon the targets. We cannot sure if it can make their distinction between military objectives, civilians, and civilian objects. The fact that the wall is also equipped with fully automatic lethal weapons, which is undoubtedly very lethal, and the absence of warrant of level and type of injury that may be inflicted by the weapon provisions, it is uncertain if this operation may remain lawful. It is indeed possible for the wall to conduct such indiscriminate attacks.
Given the estimations of possible casualties in case the wall is put, would you say that it's in favor of the civilians and other people in general, because the wall usually assumes that those are not threats?
Make your argument.
I should put one question. Time's up. Thank you very much.
If the